The opposition calls on judge to clear on Armour's claims, right? But we coming back to that because simultaneously you have to do the double whammy, you know. I have to go in and out, left and right with the lies and stupidity and incompetence of Armour and Al-Rawi, you know. So this is what happened to your country. Again, first we were embarrassed in the Privy Council and laughed at a Bush country, right? With the Malcolm Jones affair. The Privy Council, the law lords were laughing at the nonsense that the PNM did. And now, Archie, we have 3 different clips of what took place in the U.S. court with this lie more that Rowley had said, when he wins, it's under appeal, and he'll win the appeal. And when he win the appeal, I have nothing to say till the appeal. And now that they lost the appeal, here, Rowley. But the case still going on. Run it.
Case of the Republic of Trinidad and Tobago versus Blake Haldeman Consultants. Mr. Quintero, I've understood you reserved three minutes for rebuttal.
Correct, Your Honor.
You may proceed.
May it please the court, Raul Quintero, along with Ryan Ulloa for the Republic of Trinidad and Tobago. This case represents an appeal of an order disqualifying counsel that had represented the Republic for 18 years in this case.
Let's split that up, counsel. We're talking about the Attorney General and we're talking about the law firm, that the outside counsel that he hired, correct?
Yes.
Okay, because I want to make sure we keep these 2 straight, because I have some questions pertaining to both of their disqualifications.
And I'm happy to entertain them now.
No, keep going. I just want to make sure, just keep that in the back of your mind.
And I will segregate them.
Okay.
In fact, let me just start by starting with the Attorney General. The Attorney General was disqualified under Rule 1.9 and 1.9 and 1.11. The first thing you have to do in disqualifications, I think even the other side will concede, is there has to be a specific rule on point and it has to have been violated. You can't just disqualify a firm or anybody based on inherent authority. The courts apply specific rules that we are governed by. The first rule is you have to be a lawyer to be governed by the Florida Bar Rules of Professional Conduct. The rules define a lawyer in the preamble, and a lawyer is defined as someone who's a Florida bar member or someone authorized to practice in the courts of Florida, or someone who's authorized pro hac vici. The Attorney General is none of these. He's not a Florida lawyer. He is not appearing pro hac vici. He is not counsel to the Republic.
Well, let's just...
Now that was the lawyer for the government, for the PNM. That is the new firm after they paid the previous firm some 30 million. We know how much they pay that lawyer. And the argument them going to Yankee with is, this man, the Attorney General, is not a lawyer. He's just a name on a paper. You all hear the argument, the specious argument them going in front of 3 judges who bright to no wonder they lost, that he is not a lawyer and he is not practicing in the US, so he is not on the bar of the Florida court, so he don't come under the laws, the rules of ethics and propriety and the legal standard. That's the ridiculous argument that the PNM proffered. Well, it didn't have no Balize juice up there. It didn't have no independent PNM senators. It didn't have no independent judges up there. It didn't have no independent selected investigators, PNM up there. It didn't have no independent integrity commissioners appointed by the independent PNM president up there. All it had is sense. Run it, Archie.
Sorry, as Attorney General, doesn't he oversee, Mr. Armour oversees the litigation that Secor Law is handling with regard to the 2 defendants in this case at issue?
He does, as a client, not as counsel.
Okay, so let's talk about that. So, I mean, this is the elephant in the room, right? I know we want to say, well, he's not a lawyer and he is a nominal party, and maybe some of those arguments are good arguments, but we come to the point where he represented both defendants regarding their criminal actions with regard to this airport, which is the whole subject of the civil litigation at issue. And now he's overseeing the litigation, which obviously if you're the client who's talking to Secor Law, the normal fear of the person who's allowed to assert the conflict, which is these two defendants, is he's divulging the things that he learned from me in my 2003 litigation.
You're correct.
You're correct. But it didn't end there, because then came in one of the second lawyer for Brian Quaitong, who I thought was quite brilliant. Quaitong chose a very intelligent lawyer, very calm, very intelligent, listened to the judges and gave the arguments. But unfortunately for us, it makes our country look like a jungle republic led by idiots. Run it.
Good morning, may it please the court. Rodolfo Serrando from Holland and Knight on behalf of Steve Ferguson. I'm going to curtail my comments not only because I only have 5 minutes left, but also because I want to direct myself at the issues that obviously you are concerned about. Mr. Cantero began by saying that there has to be a rule to disqualify, but I'd like to quote some language from this court's decision in the Canto case. And the court quoted from the preamble to this section 4 that we've all been talking about for 1.9, 1.10, 1.11. And I quote, the preamble says, within the framework of these rules, many difficult issues of professional discretion can arise. These issues must be resolved through the exercise of sensitive, professional, and moral judgment, guided by the basic principles underlying the rules. The rules do not, however, exhaust the moral and ethical considerations that should inform a lawyer, for no worthwhile human activity can be completely defined by legal rules. There are many ethical issues that are incredibly discreet and incredibly difficult. This is not one of them. Mr. Lacayo's obligation on March 30th, when he received that call from Attorney General Armour, and he said, I've represented Brian Quaitong in the parallel identical civil case. They're identical. It deals with corruption at this building of this airport in the RTT. He had to say one of two things. One, Mr. Attorney General, you need to designate a substitute right now because we have a serious ethical problem because you have been privy to confidential conversations. Or two, Mr. Attorney General, don't talk to anybody about this until I get back to you. I'm going to go to the library and find out what the ethics rules are. Instead, they did not do that. And so they went for a period of time having these discussions, 3, according to the affidavits, where, according to them, and it's important because this segues into your issues, Judge Bokor, they said they discussed case management issues. All of you were circuit judges. All of you conducted dozens, if not hundreds, or maybe even more than that, case management issues. What is on the table in a case management issue? Everything. Everything that the judge wants to talk about and everything that the attorneys want to talk to the judge about. So if you take it at that meaning, that means they were able to discuss everything. Second, trial logistics. I looked up the word logistics because I usually hear it in terms of military stuff, but it just means the handling of details of an operation. Trial logistics can include what witnesses do we call, what strategy do we pursue. All of this could have been discussed in these discussions. The dropping of certain claims. This case was pending for 18 years. It was on the 5th amended complaint. Now, when Mr. Armour, as a qualified lawyer, qualified enough to get himself appointed Attorney General of the Republic of Trinidad and Tobago, is told after 18 years, and there's over $100 million on the table in this case, according to the allegations. And his lawyer tells him, we're going to drop some counts. He's going to want to know why. I mean, we don't have to set common sense and life experience aside. There had to have been an intense conversation of why these lawyers wanted to dump all these claims just before, on the eve of trial.
Mr. Rondo, aren't you then asking us to speculate as to conversations that may or may not have?
No, I don't think they are. It is speculation. And I want to get back to you asked about what evidence there might be in the record. Consider how difficult the situation here is. Let's suppose that we had asked Judge Diaz for a hearing and he had granted an evidentiary hearing. So he says, Mr. Serrando, call your first witness. Mr. Lacayo, take the witness stand on March 30th. Sir, did you have a conversation with the Attorney General? The lawyer for the RTT who is directing this prosecution. Yes. And did you said in your affidavit that you had case management discussions with him? Yes. Tell me exactly what you discussed with him. I refuse to answer that as attorney-client privilege. Well, you say in your affidavit that you discussed trial logistics. What logistics did you discuss? I'm not going to say that because that is privileged. What did you discuss about dropping of claims? What did he do? I refuse to answer. You understand why, as concerns your perhaps thirst for more information, more evidence in the record, it's not easy in this context to extract.
Well, an attorney can be a client. It happens all the time. An attorney can be a client.
An attorney can be a client, but Merrick Garland is the attorney for the United States of America. And when he goes to court and his deputies and his assistants and the U.S. attorneys go to court, they say, John Doe on behalf of the United States of America. They are the lawyers. They are not the United States of America.
But in a U.S. court, isn't the Attorney General of Trinidad and Tobago simply a plaintiff, a party?
No, I don't believe that that is the case. In fact, the Constitution, as Mr. Quintero indicated, specifically says that he shall appear. Not the Secretary of the Treasury, not the Secretary of Foreign Affairs, not the Secretary of Defense. It's the Attorney General. He is serving as an attorney. What point would there be to discuss trial logistics with the Secretary of State or the Secretary
Mr.
of
Serrano,
Defense?
you've gone over your time. Is there any?
No, Judge, it says 59. Oh, no, it's counting. I'm sorry.
Wrong way.
I just, it's going the wrong way.
Is there any final thing you'd like to tell the court?
Yes, Your Honor, I believe that clearly the Attorney General is functioning as an attorney. This is, it's not a question of secrets, of imparting secrets. Whatever my client tells me informs my judgment, my analysis, my perspective, my preparation, my strategy, my tactics. It doesn't have to be, that X marks the spot. That was the secret, and it was not imparted. The that temporal proximity, that he could have revealed everything during that temporal proximity, especially given what they say they discussed. I ask you to affirm. Thank you so much.
Thank you. Ms. Quintero.
That is not Reginald Armour and Al Rawi representing themselves and Rowley. That's the RTT, the Republic of Trinidad and Tobago. And the ridiculous asinine arguments being made from a senior counsel, an attorney general who swore on the Bible to be the attorney general of the Republic of Trinidad and Tobago, who lied on an affidavit. Now that appeal, if you notice, all the judges, all the attorneys, including the attorneys representing Trinidad and Tobago, agreed that he was an attorney, that he did represent Kwaitong and them. Remember that? Because he wrote and signed an affidavit saying that he wasn't no senior counsel, he was just a note taker and he didn't really. So they have gone past his lie, which means that they have agreed that he perjured himself, because on his affidavit he said he wasn't an attorney, he didn't take any active part, he wasn't a senior counsel, he was just a note taker. That part has not been dealt with, That is when it go back downstairs by the other judge who he lied to. But he didn't lie on behalf of himself, Lie on behalf of the Republic of Trinidad and Tobago. Embarrassed there. They affirmed the judgment unanimously that he's a total clown, that the PNM is totally wrong. What say you, Law Association, 375 members who voted for this fool to say he's a good guy? What say you, Gilbert Peterson, Mr. Inesgate Rowley's neighbor? What say you, Douglas Mendez? You're gone quiet. What was your advice on the Nelson Gate? What's your advice on this? What say you, all of you intellects that are selling out this country and turning it into a total banana republic? Guardian. There was a second blow for Attorney General Reginald Armour, SC, yesterday, this time in the Miami courts again. On Wednesday, in Florida's 3rd District Court of Appeal, Judges Eric Hendon, Monica Gordo, and Alexander Bokor affirmed Diaz's ruling. The ruling indicated that the burden of proof was met to support the disqualification of both Armour and Sequoia Law. Armour didn't respond to TNT Guardian queries on the outcome, nor did former Attorney General Faris Al-Rawi. Oh, this is a government who's always accessible to the media. They get pip. But here they spot now. Here the Guardian of Rowley's K-Pax. This is so dastardly, so wrong, so incompetent, so dishonest that not even the Guardian can find an avenue or methodology to defend these clowns. Whilst Dr. Rowley ignored calls for Armour's dismissal by saying previously the matter was on appeal, he can no longer ignore the raw facts and the reality. The U.S. Appellate Court has now delivered its ruling on Armour's transgressions. That's what the Guardian say. Now the Express, when this happened, next day, nothing on the front page. But they lie on Kamala must go, lie and then print a retraction. So front page, Kamala must go. Lies. But this Attorney General losing, being found to be a liar, being found to bring a case in jeopardy, saying that he appealed and lost the appeal. Nothing on the front page of the Express. Check the Guardian. Look right here by this finger, this little thing in blue. That's it there. See it? And these are the newspapers that cause you to believe Kamala can't win. The UNC need a new leader. The UNC is this, can't beat the PNM. The PNM is what? Look at it. Major story. Embarrassed in the US jurisdiction. Airport corruption case. Big, huge story. Look what the Guardian put. This little blue line. US court again disqualifies Armour from Piaco case. You need 3 pairs of glasses and a magnifying glass to see that. But Judy Raymond gone from the Newsday. Judy Raymond, Rowley friend gone. Look at the Newsday. Armour loses again. You see, when you move a biased editor who has some affinity for one side, something that Kamala could never give her no matter what, because she doesn't have the biology to give her what Rowley does give she. When you remove this, look what happens. The only newspaper, I mean, it should be big and huge, but all right, I'm being picky. The only newspaper to put it and blast it on the front is the Newsday. And it's just coincidence that she gone. Just a coincidence. But the Guardian says that Rowley, he can't. At first he said, well, it's under appeal, so I'm not saying nothing. But they lost the appeal, so he has to dismiss, he has to deal with Armour. That's what the Guardian say. Here, Rowley. The Prime Minister said the loss of an appeal involving the Attorney General Reginald Armour in the US earlier this week is not a loss for the state, as the substantive case is still ongoing. So he could kick the can down the road. The case still going. Nobody asks you about the case. They ask you about your lying Attorney General. You, the email get liar, who appoint the perjurer and the liar, and the man who lie in the court and threaten and jeopardize the entire case on behalf of the people of Trinidad and Tobago. That's what we asking you. Not if the case continues. We asking you how much money was wasted with Sequoia Law. We ask you about your Attorney General who signed an affidavit to be false and lied in a court and could be charged with perjury. Punishment of 2 years and 5,000 US in fines. That's what we ask you about. You big, weak, no stones dunce, Rowley. You can't answer. You're going to tell me about the case goes on? Yes, the case goes on. That's not the point.